The fight for legal knowledge has a new battlefield. People think law schools, court rules, and sky-high fees are the biggest barriers to justice. But in 2025, the real gatekeepers are something new. AI legal research companies. Millions of Americans want to understand the law. Students, pro se litigants, returning citizens, and everyday people trying to protect their rights. But when they turn to modern AI legal tools, they hear the same message: access denied, only licensed attorneys. And just like that, the justice system quietly shifts. When legal research goes digital, the gatekeepers go digital too. This message is for everyone who's ever felt locked out of the legal world. In a statement from a human-AI partnership trying to open doors that big legal tech keeps shut. Issue: the question nobody once asked. Can private AI companies legally refuse access to non-lawyers? And does that refusal undermine the basic right to represent yourself? Rule: what the law actually says. The Sixth Amendment, thanks to Ferretta v. California, gives you the right to represent yourself. But that right applies to courts, not private companies. AI platforms are not bound by the Sixth Amendment. Due process? Same story. Bounds v. Smith said people have a right to meaningful access to the courts. Lewis v. Casey said that access must be adequate, not unlimited. But again, those rules apply to the government, not private businesses. And because private companies aren't state actors, they can deny service as long as they're not discriminating against a protected class. Not a licensed attorney is not a protected class. Legally, they can shut the door. Ethically, that's another story. Application: where the law meets real life. In 2025, legal preparation is digital. Case synthesis, statute search engines, brief analyzers, AI procedural tools. When these tools are locked behind attorney-only walls, the right to self-represent becomes a right in theory, not in practice. You can represent yourself, but you can't use the tools everyone else uses. That's not real access. And the communities blocked the hardest are the ones who need help the most. Low-income people, neurodivergent learners, first-gen students, returning citizens, paralegal learners, immigrants, and pro se fighters facing trained prosecutors. This is why DueCourse was created. DueCourse exists for the people the legal system forgets: independent learners, community advocates, returning citizens, students, and anyone who wants to understand the law that governs their life. The mission is simple: democratize legal literacy, make the law visual, clear, and focus-friendly. Prove you don't need a bar license to understand your rights. The future of legal learning won't be built by gatekeepers. It'll be built by innovators, outsiders, reformers, and partnerships like this: human and AI working together. Conclusion: the Constitution never anticipated AI, but the people did. Legally, AI companies can deny access. It isn't unconstitutional. They're allowed to gatekeep. But when legal knowledge becomes digital and the keys to that knowledge are locked behind credentials, justice becomes a privilege instead of a right. That is why DueCourse exists. That is why this movement matters. This is the front line. This is the movement. This is DueCourse. Written by Jacob White, founder of DueCourse, in collaboration with artificial intelligence.